afternoon and good evening, everybody. My name is Dr. Dini Seiko. I am a research associate at the Chinese University of Hong Kong Faculty of Law. And today I'm very glad to present to you the EU-China Investment Relations Seminar Series. This is an initiative organized by the Center for Comparative and Transnational Law at the Chinese University of Hong Kong in collaboration with DLA Piper Vienna and University College London. This initiative is the product of many meetings between myself, Dr. Alessandro Spano from UCL, and Ms. Tuche Yalchin from DLA Piper. So last spring, we started to discuss about what can we do after the signature of the Comprehensive Agreement on Investment between EU and China. And we thought that with the Belt and Road and so many challenges after the Belt and Road that have faced, that the world is facing, and especially EU and the relation between China and EU are facing, we decided that a seminar series on EU-China is a very interesting topic to discuss. So first of all, the first seminar, today's seminar, we will focus on the most topical investment issues. And the next seminar, which will take place in December, will focus on sustainability matters. And in January, the seminar in January, we will discuss about innovative global value chains and tech and data. And the last seminar is going to be focused on the relationship between China and the former EU member, UK. So I hope you will join us today and in the following seminars for interesting discussions between academics and practitioners. Today, we have here also the ambassador of the European Union in Hong Kong Special Administrative Region. Now I'll give the floor to the chair of today's seminar, Professor Rehan Abiratne, who is also the executive director of the Center for Comparative and Transnational Law at the Chinese University of Hong Kong. Thank you, everybody.
Thank you very much, Dini. Welcome everybody to this first seminar on EU-China investment relations and the FDI regime. My name is Rehan Abiratne. I'm an associate professor here at the Chinese University of Hong Kong Faculty of Law and the executive director of our Center for Comparative and Transnational Law. In my brief remarks today, I'd like to introduce all of you to our center, CCTL. And then hand over to our dean to make some welcome remarks as well. So CCTL was founded in April 2020. It's a large umbrella organization for faculty members to form research clusters and pursue research collaborations and research projects with the institutional support of the center. We have 7 clusters covering a wide range of legal areas, including a transnational economic law and dispute settlement group, which has organized today's event. We do not prioritize any particular subject matter. Rather, we think of CCTL as a site of coordination and for building links, both among our faculty as well as with external bodies. And I'm particularly delighted to inaugurate this seminar series because it builds links not only with an academic institution, the University College London, but also with legal practice, with the leading global law firm, DLA Piper. So I'm particularly delighted not only that we have this seminar series, but that we are forming these relationships, which I hope can continue, not just for these 4 seminars, but beyond that as well. For those of you in the audience, if this is your first CCTL event, I hope it's not your last. We have organized about 50 events so far, online seminars, symposiums, conferences, and book talks. You can follow us on social media. We're on Twitter, Facebook, and LinkedIn at CCTL or at Center for Comparative and Transnational Law. You can also see videos of our past events on our website, the CUHK Law website, and on our YouTube channel. So Please attend future events. You could sign up for our mailing list and be notified every time an event is held. And we would love to see you in the future. So that's it for me for now. It's now my great pleasure to introduce our Dean, Professor Lutz Christian Wolff, the Wayland Professor of Law here at CUHK, to deliver his opening remarks.
Thank you very much, Rivihan. Ambassador Gnocchi, ladies and gentlemen, very warm welcome from me to all of you on behalf of CUHK Law. China has established itself as a global mega power over the past 2 decades or 3 decades. And this development was first welcomed, if not requested, but has led to a lot of concerns in recent times. And everybody, including China herself, has yet to come to terms with China's new position. And everybody has to define its own strategy in this context. The EU is, of course, playing a very special role in this regard as a union of states with rather diverse interests, which have to be balanced against China's international ambitions on the one hand, but also just, of course, on the other hand, great opportunities for collaboration with China. Chinese investments in the EU and Chinese outbound investments in China play a key role in this regard. And I'm very happy that the CCTL, Transnational Economic Law and Dispute Settlement Group here at CUHK Law have joined forces with DLL Piper and UCL to organize today's event. And in fact, the seminar series, which as Dr. Dini Seiko has explained a minute ago, will run over the next couple of months. CUHK Law has a long history of impactful research in the area of international economic law, and I trust that today's event and the events to come will continue this very proud tradition. Special thanks go to Professor Brian Mercurio and Dr. Dini Seiko for being the masterminds and driving force behind the organization of the seminar series. Special thanks also to the CUHK Law admin team for taking good care of the logistics. Many thanks today to Ambassador Gnocchi for honoring us with the keynote, and of course also to the panelists and discussants for their contributions. And last but not least, a big thank you to the audience out there for joining us today. The large number of registrations shows the importance of the topic that is today addressed in today's seminar. I wish all of us 2 very interesting and thought-provoking hours, and I will stop here and pass the floor back to the chair of today's sessions. Over to you, Rihan. Thank you.
Thank you very much, Dean Wolff, for those welcome remarks. It's now my pleasure to introduce our keynote speaker, Ambassador Thomas Gnocchi, who is the head of office of the European Union to the Hong Kong SAR and the Macau SAR. Ambassador Gnocchi started his assignment as the head of the EU office to these 2 SARs on September 1st, 2020. Prior to that, he was deputy head of division for Japan, Korea, Australia, New Zealand, and the Pacific, and deputy head of division for Afghanistan and Pakistan at the European External Action Service in Brussels. He has served as deputy head of office and head of the political, economic, and European integration section at the EU office in Kosovo between 2012 and 2017, and as head of the political and information section at the delegation of the European Union to Serbia between 2008 and 2012. Prior to that, he has held several posts at the European Commission. Ambassador Gnocchi was educated at the London School of Economics, Yale University, and Tianjin University in China. So with that, let me invite Ambassador Gnocchi to give his keynote address. Thank you.
Thank you very much, Chair, Professor Abiratne, Professor Wolf, Dr. Seiko, Dedini. It's a real pleasure to be addressing this, the first of this seminar series, which you have organized under the Center for Comparative and Transitional Law at the CUHK Law Faculty. On behalf of the European Union office here. It looks like it's a very interesting series of seminars, very interesting topics which are, I think, very relevant for our work. And so it's a real pleasure to be able to address you in this first series. I'm also joined by Walter van Hattem, who is the head of our trade section, who follows trade and investment matters very closely. I'd like to start with just an overview on the EU's trade and investment policy. I think it's important to put the overall paint the overall picture of where we stand with this policy. And I'd like to say that firstly, that the EU economy after the period of the pandemic, which is still ongoing, but the EU economy is coming back to motion. Most recent GDP figures are going up substantially. It is expected that the EU GDP will grow by around 5% in 2021 and at a similar rate in 2022. And trade is a key to this growth, and our new trade strategy, which was launched this February, gives us also an additional boost. Our trade policy aims to be open, sustainable, and assertive, and I'll address these three elements in turn. First of all, on the openness. It is likely that this year, our trade levels will reach a record of 4 trillion euros. And in 2020, the trade figures generated almost 40% of the EU's GDP. Trade supports 38 million jobs in the EU, which represents an increase of 9 million people in 1 decade. And this really plays a crucial role in helping us recover faster and emerge from the crisis much stronger. This openness will be even more important in the future, as 85% of global growth will occur outside the EU in the next decade. And this is why we work on a stable global trading environment. As part of our strategy, the EU has set its vision for a reformed World Trade Organization, and the upcoming 12th Ministerial Conference provides an opportunity for working with both Hong Kong and China. In parallel, we also keep investing in our bilateral trade partnerships around the globe. The EU's web of trade agreements is the largest network in the world. We have 46 deals with 78 partners. And this is a source of significant strength on which we will continue to build. Our new trade strategy is also the greenest ever, turning to the sustainability aspect of our trade policy. And this includes bringing forward climate and sustainability as key topics that are discussed under the WTO, seeking commitments from the biggest emitters, notably G20 countries on climate neutrality, negotiating and implementing ambitious trade and sustainable development chapters in our trade deals, making the respect of the Paris Agreement an essential element of our future trade agreements, having a WTO-compliant carbon border adjustment mechanism, which will allow us to effectively deal with carbon leakage and incentivize greenhouse gas emissions reductions among trading partners, and also legislation to avoid placing products issued from deforestation on the market. So trade is not only the tool to solve these problems, but it definitely makes an important contribution. The third element is how we intend to implement all this and the focus that there is on implementation, because it's not only important to have the framework in place, but this framework also needs to deliver, and the trade agreements need to be respected. So we have to make sure that our partners fully implement their commitments on trade and sustainable development, including on climate and labor rights. We have to be more assertive and defend ourselves when our partners do not play by the rules. For this reason, we recently appointed the first EU Chief Trade Enforcement Officer. We also continue building our own toolbox of unilateral trade measures where we cannot get fair treatment through negotiations in a multilateral context. Regarding the economic level playing field and fair and reciprocal treatment, the existing tools include enforcement mechanisms such as the EU's trade defense instruments and our actions through the WTO dispute settlement. In May 2021, the Commission adopted its proposal for future foreign subsidies instrument, which will address distortions in the single market stemming from foreign subsidies through direct investments, public procurement contracts, or other economic competitive activities in the EU. Besides, there is also good progress on the international procurement instrument, and we hope that the final legislation can be adopted next year. Then there's the planned anti-coercion instrument. The aim of the tool is to create a framework for the EU in specific situations of coercion to take various restrictions towards the country applying coercive measures and also to deter such measures in the first place. The EU is also developing instruments related to core values such as human rights and sustainable development. The global human rights sanctions regime was adopted in 2020, and the Commission is working on its proposal for a corporate due diligence instrument. We plan to ban imports of products made with the use of forced labor through this instrument. So while our trade policy focus may be changing, one thing remains constant, and that is the central importance of trade for our priorities, be they economic, environmental, social, or political. Turning to the EU-China relationship and trade and investment in particular. Our trade agenda will also depend on our global relationships at large. And one of the most important ones is clearly the one with China. In 2020, trading goods between the EU27 and China totaled 586 billion euro. For 2021, this could reach as high as 650 billion euros. The Chinese market is of great importance to our companies. It is the third largest destination for our exports after the US and the UK. The EU is also an important market for China. 15% of Chinese exports go to the EU, making it its second largest export destination. China continues to be eager for foreign investment, and European companies are uniquely placed to contribute to the continuing development of China's economy, including in innovative sectors. Turning to the challenges, our relationship, however, does face a number of growing challenges. For example, Chinese counter-sanctions imposed on members of the European Parliament and think tankers in March this year put the comprehensive agreement on investment on hold. We have a difficult political context for EU-China trade relations following these sanctions, and China's increasingly assertive behavior, both at home and abroad. In addition, China's economic policy is increasingly diverging away from market economy principles. The European Chamber of Commerce in China in its annual report spells out a number of concerns with regards to China's economic trajectory. The 5-year plan and dual circulation strategy represent a shift away from the growth model driven by foreign investment and exports. More emphasis on domestic demand, technological innovation, and self-sufficiency. While this is positive, the focus on self-sufficiency and indigenous innovation also risks displacing EU companies. China is putting in place various requirements on data localization, control of data flows, restrictions based on a broadly defined concept of national security that are contributing to a technological decoupling. In view of these trends, there is a growing concern about the increasing politicization of the business environment in China. So what is the EU approach? The EU's multifaceted approach to China is still valid. Indeed, our past engagement has delivered positive results, notably the agreement on geographical indications, and the process which led to the political conclusion of the Comprehensive Agreement on Investment, which I mentioned earlier. So disengagement is not an option. China remains a key partner to tackle global issues such as climate change, the response to COVID, and reforming global trading rules. So we have to engage. And in recent months, we have engaged with China, notably on the issue of WTO reform. And it has been 20 years since China has joined the WTO. Since then, it has become a major economic partner for over 120 countries, contributing almost 30% to global economic growth. We encourage China to adopt an approach that is commensurate with its global economic impact, for instance, by following the example of other WTO members who agreed to refrain from the benefits of developing country status. For the EU, the importance of such economic engagement goes hand in hand with the importance of a rule-based trade to ensure fairness, legal certainty, and a legal playing field, as well as upholding universal values and international norms. In conclusion, despite the latest challenges, our multifaceted approach towards China remains valid, as this approach ensures that we stand up for and defend our values, while at the same time remain pragmatic and realistic. The EU approach, which in March 2019 defined China concurrently as a cooperation partner, a negotiating partner, a competitor, and a systemic rival, still remains broadly valid today. The EU will maintain its overall approach to open and fair trade in line with its open strategic autonomy. We are engaging and working on areas of multilateralism and WTO, in the areas of green finance and climate change, strengthening our rules-based trade order, and also on our values. While we put in place these measures, we can better level the playing field where and when needed. The EU is coming out of the current crisis stronger, thanks also to the role of our trade policy. And we want to continue to discuss these issues and engage with countries around the world, including important partners like China. Thank you very much.
Thank you very much, Ambassador Nyaki, for that address. I think we will now move on to the panel. The panel today, we have 4 presentations. Let me introduce all the speakers now, and then I'll invite them one by one to give their presentations. First presentation will be on Belt and Road Initiative and the Chinese FDI in Europe, geoeconomic objectives and transnational regulatory framework. The speaker is Dr. Dini Seiko, one of the co-organizers of this event. Dr. Seiko is a research associate at CCTL here at CUHK Law, and a research affiliate at the Fletcher Network for Sovereign Wealth and Global Capital at Tufts University. He's the author of the forthcoming book, The Transnational Law of Sovereign Wealth Funds, Governing State Capitalism at the Time of Protectionism, which is under contract with Edward Elgar Publishing. Dr. Seiko has degrees from Bocconi University, as well as a master's and a PhD in law from CUHK. The second presentation will be on the EU-China Comprehensive Agreement on Investment, Potential Impact and Uncertain Future. The speaker is Brian Mercurio, the Simon F.S. Lee Professor of Law here at CUHK Law, who has also served as Associate Dean of Research from 2010 to 14, and again from 2017 to 19. Professor Mercurio specializes in international economic law, with particular expertise in the intersection between trade law and intellectual property rights, free trade agreements, trade in services, dispute settlement, and international investment law. He is the co-author of one of the most widely used textbooks in WTO law, which is currently in its 3rd edition with Hart Publishing. He's also the co-editor of one of the leading collections on bilateral and regional trade agreements, which is now in its 2nd edition with Cambridge University Press. His most recent monograph explores the international and domestic framework for pharmaceutical patent law and policy. It was published by Cambridge University Press in 2018. And his next monograph will focus on the legality of capital controls under various strands of international economic law, which is also going to be with Cambridge University Press, published in the next year. The third presentation will be on the EU's new FD screening regulation and its impact on M&A transactions, a practical perspective from Europe and Asia. I believe there was originally supposed to be two speakers for this one, Dr. Christoph Mager and Ms. Tudse Yalcin, but Ms. Yalcin unfortunately is ill and cannot make it. We wish her a speedy recovery, and also I want to reiterate our thanks to her for being a co-organizer of this event. Let me introduce Dr. Mager. So Dr. Christoph Mager is a partner and head of Austrian corporate M&A department at DLA Piper. His extensive experience in cross-border M&A transactions, corporate structuring, and reorganizations. He focuses on advising high net worth individuals to structure their asset allocation, and he's a recognized advisor for Austrian private foundations and foundations in Liechtenstein, which he also uses to manage for clients as legal advisor and as a member of the management board. In addition, he has a thorough understanding of the automotive and life sciences industries and regularly advises clients on industry-specific matters and transactions. Finally, we have a presentation on the interplay of competition law and trade policy in contemporary China. The speaker is Mr. Nathan Bush, partner and head of Antitrust and Competition of Asia at DLA Piper. Mr. Bush advises clients in international investigations, government enforcement actions, and compliance matters in Asia. He was based in Beijing from 2004 through 2012 and has covered Asia from Singapore since 2013. He pioneered antitrust practice in China and guides clients through anti-bribery and anti-corruption risks in Asia's dynamic markets. Mr. Bush also advises on antitrust merger notifications, compliance strategies, and enforcement risks under Asia's evolving competition regimes. He leads innovative multi-jurisdictional approaches to antitrust regulatory inquiries, litigation, and policy advocacy, and represents clients in US merger review and antitrust litigation matters. Those are our speakers. In addition to that, we are very pleased to be joined by a discussant, Joel Slovatsky, who teaches at the Harry Radziner Law School at Reichman University in Israel, where his primary areas of research and teaching focus on corporate and economic governance, international economic law, national security, and global governance. He has taught, lectured, and presented at conferences in Asia, Europe, North and South America. And Professor Slovatsky also has published over 50 journal articles and book chapters in various leading forums. So thank you very much to all the speakers for attending and for speaking at this panel. Let me just say one thing before I invite Dr. Seiko, which is for members of the audience, if you have questions, please feel free to send them to me, Rehana Viratna, through the chat function in Zoom. So send me your questions. You can send them at any time. And at the end of all the speakers, we will hopefully have some time for a Q&A session. Okay, so with that, let me hand over to the first speaker, Dr. Denis Seiko. Thank you.
Okay, thank you. So thank you, Chair. Thank you, Mr. Ambassador, Professor Wolf. Now it's my turn to discuss one of the most discussed topics in actually international economic law and also in geopolitics, international relations. Some studies before the COVID said that it was one of the topics on which scholars and journalists had more written. In fact, even here, between myself, who is the youngest one, Professor Wolf, and Professor Mercurio, there is already a lot of scholarship on the topic of Belt and Road. So what I'm going to do now is just trying to set the scene for the following presentations and provide the basic information to open the discussion. So the Belt and Road Initiative was the signature initiative of the Chinese government, and it started in 2013. In autumn 2013, the leadership of the Chinese, of the People's Republic of China, in two different occasions, once in Kazakhstan, the other times in Indonesia, they started to promote the two items, the two main parts of the Belt and Road Initiative, which are the maritime, the maritime. The maritime initiative and the land initiative. So I'd like to move to the second slide. So the Belt and Road Initiative is based on historical routes, which are the Silk Roads, and they go back, as it was already mentioned, to the trade routes that connected Europe with China. They were some scholars say that they were as old as the connections between the Roman Empire and China. Others give them more modern routes. But what is important now that based on these ideas and past ideas, the Chinese government has issued significant initiatives that will connect that are connecting different parts of China with the world. So one, the Belt and Road Initiative was initially promoted. There was lack of clarity about the Belt and Road Initiative. So at the very beginning, it was what people thought to be just a slogan, but with a slogan that started to take shape. And for the first time, the significant project and the significant objectives of the Belt and Road Initiative were made public in March 2015. So 2 years after the launch of the initiative. So the Belt, after the launch of the initiative, and the So the document issued by the State Council with the support of other entities in China clarified which were the objectives of the Belt and Road Initiative. The objectives of the Belt and Road Initiative were to promote a free flow of capital between China and the rest of the world, a better allocation of resources between China and its economic market with an intent to deeper integrate the markets. And in this sense, it has also a geopolitical objective, both internal and external. So from the internal dimension, for example, it has the objective to develop the western side of China, which has not benefited as much from the growth of the Chinese economy in the past 30 years compared to the rest of the Chinese territory. And it also it has the objective to increase cooperation, regional cooperation in China. In fact, they were talking about the impact of the Belt and Road in the European markets. But another region which is significantly affected by Chinese investment is the ASEAN region, Southeast Asia, where Chinese investments are competing with other important investments and are competing also with European investments. So the Belt and Road, as it has also been said, it is now an umbrella term that serves to cover all Chinese Chinese economic interactions, and it gives also a platform to Chinese investors. Chinese investors involved in the Belt and Road Initiative, as we will see a little bit later, are of different types. They are private investors, but more significantly, they are public investors. They are Chinese SOEs and they are Chinese sovereign wealth funds, which are involved in the financing of the project, and they are involved also in the implementation of the project. So the Chinese development banks and the China Investment Corporation, the Silk Road Fund, and other Chinese investment vehicles, they provide the funding for the investments in different sectors, mainly in infrastructure. So we can see in the map here that stilizes the connectivity routes, but those lines represent railways, those lines represent pipelines, those represents deep sea ports and other major infrastructure projects, including significant investments in the energy sectors and electrical grid lines, connections between several countries in Central Asia and in Southeast Asia. And as part of this variety of sectors, we can see the diversity of Chinese investments. And the main actors in these investments are Chinese SOEs, which which create significant concerns in the host countries. So in the host countries, there are concerns about national security related to these investments. But let's move on and focus on the regulatory aspects. So as I was saying, the significance of the project was clarified by the Chinese government only 2 years after the launch of the initiative. So main Chinese bodies, the National Development and Reform Commission, the Ministry of Foreign Affairs, Ministry of Commerce, and the State Council issued what is the most important document regarding the Belt and Road Initiative, Vision and Actions on Jointly Building Silk Road Economic Belt and the 21st Century Maritime Silk Road. So when this document was launched, there was no clear list of the countries that were involved in the Belt and Road Initiative. Several studies at the time gave a number of around 60 countries involved. But now the number of countries has grown significantly and covers more than 130 states that has signed with China different types of agreements. What it is important, however, to emphasize that none of these agreements is an instrument of hard law. It's not, none of these agreements is a treaty. The main instrument that China has used in order to promote the Belt and Road Initiative are declaratory instruments or so-called soft law instruments. So as memorandum of understanding signed at the governmental level between China and the member states of the EU, for example, and or other countries, or also a memorandum of understanding signed by Chinese provinces with specific regions in the EU in this case, but also in other areas. So the main base of the regulatory framework is are the old treaties that China has signed. China has signed treaties with the EU starting from the opening up in the early 80s. So the first treaty that China signed with the EU member state was a treaty that between China and Sweden, and followingly all member states of the European Union, except Ireland, have signed BIT with China. And those BITs are the instrument that provide protection for Chinese investors investing in Europe. What is particular about China is that China has changed its approach to the negotiations of BIT. So the early stage BITs, there are BITs that China was willing to sign at the time. It was still a very defensive economic actor. So they were mainly a recipient of foreign direct investment. So the type of protection that they were willing to give to foreign investors investing in China in the 80s and the 90s were very limited. So now they are facing the same problems because those protections are also granted to Chinese investors that are investing abroad. So and for this reason, the Vision and Actions Plan recognizes a necessity for the Chinese government to negotiate a new set of rules in order to protect Chinese investments. In addition to the BATs, now you can see also on the slide what I was referring to. In addition to the BATs, there are also other platforms that China has been using in order to implement its strategy. So in different areas of the world, China is using different instruments. And what is significant for the case of Europe is the China and Central and Eastern European countries initiative, also known as a 17+1, which comprises the Eastern European countries and China. Actually, this is not a platform that was established specifically for the Belt and Road Initiative. It is an earlier platform created by by the previous Chinese government during the Go Global initiative, which is the first initiative that provided support for Chinese investments abroad, and it is now significantly used to support Chinese investments in Eastern Europe. This platform is creating some problems to the coherence of the policy of the European Union. And some of these countries are not yet members of the European Union. For example, Serbia, they have started to have deeper connections with China, and especially in the last 2 years as part of also the so-called Health Silk Road. There has been a deeper integration and a greater support for Chinese investments in Serbia. So in the future, this might, since Serbia and other Eastern European countries expect to enter the European Union, this might affect their participation in the European Union and their role within the Union or as future member states. So another important aspect of the Belt and Road Initiative is that the dominance of Chinese entities is going to lead to the creation of Chinese developed standards. Chinese developed standards can be that will require then European entities and other entities from other Western countries to comply with, and this regards standards applicable in payment systems, standards applicable in the new technologies such as 5G, but also standards in the railway system and the operation of electrical grids. And on the other hand, the success of the Belt and Road is opening or is creating the possibility for China to negotiate treatments, to negotiate treaties that creating its own legislative languages, treaty language that is more favorable to China. In response to this regulatory approach and to the concerns that these have led, together from what we can see in the slide, the massive increase, especially in the years pre-COVID, of Chinese investments in Europe, and in particular with the increasing role of Chinese SOEs, and as we can see in the slide from the columns in red, we can see that the SOEs are an important part of the of the investments, and these investments based on different data from different sources. The one that I use for these slides are from Rhodium Group. They show the great involvement in sensitive sectors also of Chinese SOEs, and there are various examples also for important acquisitions, such as the acquisition of the port of Piraeus by a major Chinese SOE, CUHK, which operates in the ports, which manages ports, but also other business sectors. But that triggered also the response of the European Union, and also have triggered different regulatory responses in different countries. So more significantly, in the European Union, there have been new mechanisms that have been developed at the level of the member states for the screening of investments. And through these mechanisms, for example, in Germany, the German authorities, also in collaboration with CFIUS, have blocked the acquisition of a cheap company by a provincial investment fund in China. And more recently, the Italian government last spring prevented the acquisition of a small semiconductor equipment company by a Chinese investment fund. So this shows that at the level of the member states, there have been different regulatory responses that were developed since the launch of the Belt and Road. And only in 2017, the European Union started its discussion for the creation of a specific and European investment screening mechanisms. And as the ambassador mentioned earlier, the EU-China 2019 strategic outlook, it recognizes China as a negotiating partner, but also as an economic competitor in different areas, and a competitor that also supports a different model of economic governance. So the relationship between China and the EU is very complex. This is why also the decision to support and promote this seminar series. So as I was referring earlier, there at the level of the member states and also the UK, there have been significant discussions and legislative developments for the strengthening of the powers of the executives, which are or specific executive agencies that will monitor foreign investments in the member states. In addition to the member states, there is also the EU investment screening mechanism, which started its operation in 2020, and it is only it has been active for only 1 year. In addition to this, there are also ongoing negotiations, as we will see. The negotiations that were completed for China Comprehensive Agreement on Investments in December 2020, which are the benefits and what does it changes for Chinese investments in Europe, and what does it changes for EU investments in China. But the new China investment, the new CUHK, it will coexist together with the bilateral investments treaties that member states have signed, unless there is action from the member state to cancel those agreements. And so those agreements are also problematic because some of those agreements do not provide significant protection to the investors. So I wanted to focus before concluding to a last point, which is the significance of MOUs and soft law instruments. So this is an issue that have created significant debate, especially in the press. So the fact that Italy was the first G7 member country to sign an MOU with China that would show support for the Belt and Road, and it was a significant development. But what it is important to remember and to know is the fact that MOU is not a treaty. The MOU does not create an obligation for the Italian government to provide open access to every type of Chinese investment, as some parties have thought. And what is also, this is also very clear from the text of the memorandum itself. As we can see here from the original text in Italian, it specifies that this agreement does not create international treaty obligations and does not and the agreements should be applied and interpreted in relation to the juridical obligations of every member state. At the same time, when Italy signed this agreement, France signed another agreement with China, but in that case, it was a declaration. And also that declaration that France signed, but did not cause the same political uproar that the Italian MOU created. France showed support for the Belt and Road Initiative. And we can see from the text in French, there is support as part of the EU strategy to support the Chinese initiative. So this instrument create a very complex and multi-layered regulatory framework for investors that it's also supplemented by an international cooperation mechanism under the EU investment screening mechanism. So the new EU regulation on investment screening mechanism provide a framework for coordination between the Commission and EU and partners of the European Union, which might mean members of the NATO, G7 members, or OECD members, but this is, at least in my understanding, not clearly specified by the text of the regulation. So to conclude, as we can see that there is a complexity of norms, and I want to remind that BRI is not a treaty, doesn't create so far doesn't create a regulatory framework. Domestic regulatory frameworks have been very fluid in order to provide a response, to create a response to an uproar of Chinese investments. And the new instruments, the investment screening mechanisms, might create significant troubles to the states that are planning to use them and are using them, especially in light of the lack of connection between the language of the investment screening mechanism and the obligations of the states under the investment agreement that they have. Thank you for your attention.
Wow, thank you very much, Dr. Seiko, for that really helpful and comprehensive overview of the BRI and the Chinese FDI in Europe regulatory framework. The next presentation will be on the EU-China Comprehensive Agreement on Investment, Potential Impact and Uncertain Future by Professor Brian Mercurio, the Simon F.S. Lee Professor here at the Chinese University of Hong Kong. Let me hand over to him now. Professor Mercurio, please.
Yes, thank you, Rihan, and I thank the co-sponsors and everyone for agreeing to this wonderful series, and to the attendees for making time to join us today. I apologize that I'm not there in person. I'm triple booked. I had an event at at 5 p.m. And another one that begins right as this one comes to a close. So I will not try to, I will not try to cover all of the CUHK, the Comprehensive Agreement on Investment, but really just make a few points on it. First, I'll just go over just a very brief history of it. The European Union and the Commission and China began negotiating for an agreement in late 2013. Really, the first round of negotiations was 2014. The negotiations really had quite a long period of, I guess you can say they were frozen for a bit, or at least put to the side until 2020. And in a flurry of action, the parties reached an agreement. Remember, this follows China's agreement early in 2020 with the United States on a phase 1 trade deal, and also the RCEP was concluded in 2020. So following that, in December 2020, we have this agreement of a very different agreement to what was initially foreseen by both of the parties. Of course, shortly thereafter, a diplomatic row ensues between the European Union and China. Tensions escalate, as Ambassador Noki informed us earlier, in which we had some dueling sanctions, and as of May 2021, the EU Parliament froze the ratification process. So we'll have to see where that's going to go, and I'll say a few words about that a wee bit later. I just wanted to show 2 slides on the evolution of trade in services and investment. So from the time the negotiations were essentially launched, I mean, what we see is EU exports in services to China have gone up over 100%, and Chinese exports over 54%. These are taken from a services industry association in Europe, and likewise EU outward investments, almost the reverse, to China's has risen 45%, and of course Chinese outward investment to the EU has risen almost 200%. So a lot of action in this space, even prior to, of course, the agreement. So as I say, I'll make really just simply 5 points today on the CUHK. The first one is that the CUHK is a unique agreement and creates unique challenges. I think that the name itself is somewhat misleading because it's not really an investment agreement as we know it, and it's certainly not comprehensive as we know those normal free trade agreement or bilateral investment agreements are. Rather, it's a bit of a sui generis agreement, which kind of lacks the scope, the depth, and the breadth of a typical free trade agreement. It doesn't cover goods or tariffs or even non-tariff barriers, government procurement, technical standards, IP, trade remedies, etc. But it's not an investment agreement either, in that it doesn't cover the substantive rules which we're used to seeing in those treaties. So expropriation, fair and equitable treatment, or dispute settlement mechanisms. These are, of course, curious omissions given the investment protection in this investment protection agreement, given the original EU negotiating objectives, which you can still find online. And that was essentially to have this agreement replace the host of bilateral investment treaties which EU member states have with China, which Dini referred to. Now these are going to remain in place. Now the agreement called for negotiations on enhanced investment protections and investment dispute settlement within 2 years. Of course, there are differences in views and opinions on dispute settlement. For instance, obviously, there's the new EU model of court versus the traditional investor state dispute settlement system, which China seems quite comfortable with. Diplomatic, of course, tensions, as I mentioned, probably means that those negotiations are not going to kick off as scheduled. Ultimately, obviously, the EU's aim is for these agreements to, as I said, replace the existing bits. I think it's fair to say as well that this agreement was not envisioned by Brussels or Beijing when those negotiations were commenced 7 years and 35 negotiating rounds ago, or even up until 2019, when it was essentially lying dormant. Rather, it's 2020, which changed the negotiating imperative really for both jurisdictions, but in particular, I think for China, that a sui generis deal was completed. I thought at the time of completion that it was going to be a real test for Europe. Europe has a somewhat of a credibility issue in getting negotiations ratified and implemented. And China, of course, is not Canada, it's not even Singapore or Vietnam. There are other issues which were bound to be raised. And I think having to go back and request changes from China would have not only been embarrassing, but also really quite difficult for China to agree to. Now with diplomatic relations going into a freeze, I think the comeback is going to be even more challenging. The second point I want to raise is that the agreement will not dramatically change the nature of EU investors or service operators operating in, or those that seek to operate in China. Yes, firms are going to benefit, but I think it's a real misnomer when you see often written in the press how this is really going to benefit the whole of European companies. FTAs, free trade agreements, create opportunities and market access. Investment agreements, I would say, generally create less market access, but lock in quite a lot of access. This is not to say that this agreement has no market access. Of course, there are some sectors which will benefit. The point being, though, is that this is not going to radically transform the regime in China or the operating framework with which European or other companies have to exist within in Europe, right? Europe itself doesn't really have to liberalize much here. It's already pretty open. So instead, the CUHK is really going to lock in a lot of Chinese investment liberalization. Most of what China agreed to are concessions which were on the agenda or simply repeated commitments which China's undertaken bilaterally or as part of other international negotiations. So for instance, just 3 examples here, removing the joint venture requirements on private hospitals in major Chinese cities. These have been piloted since 2014. And this doesn't go further, right? There's no removal of joint venture requirements in other cities, for instance. Opening up 50% foreign ownership in cloud services. This was initiated in 2019. Allowing auto manufacturers to invest without joint ventures for electronic and hybrid vehicles. Again, this began in 2018 with certain conditions and restrictions. This is not to say there's no value. There's value in locking in the gains, and the provisions on transparency, on subsidies, licensing, standard setting. These won't really make as many headlines, but they're also quite valuable. Point being, again, don't expect a major transformation, okay? So what did the EU get? Well, of course, there's reputational benefits at the forefront. The EU speaks quite a lot now about strategic autonomy, strategic sovereignty. The Commission stated the CUHK was a strategic opportunity for Europe to protect its interest while championing openness. You know, this is an indication that Europe can operate on the world stage. 2, expectations of a better balance between the Europe and China relationship. So again, there are certain market access gains, as I mentioned, especially in key manufacturing sectors. If you look, European manufacturing is quite concentrated in the automotive industry and basic materials industry. There are some gains there. There's limited liberalization commitments in agriculture, fisheries, mining, and energy. And there's some very interesting market opening commitments in services, financial services, maritime, construction, environmental, etc. And these are done on a most favored nation basis, which means that these are extended to actually every other country. So it's a commitment in the CUHK to Europe, but since it's done on an MFN basis, other foreign service providers will also benefit. There's also, of course, provisions on relating to state-owned enterprises, subsidy, transparency, forced technology transfer. A lot of these replicate what China had agreed to with the US in the phase 1 deal. Okay, if we move to the third point, and I have to mention it because it really got a lot of press, particularly early on, and I think in the European Parliament, it's still getting a lot of EU members of the European Parliament are discussing this, which is the sustainable development provisions. Don't expect these to change the regulatory landscape in China, but I say they shouldn't be expected to do so. So there are provisions on value-based investing. These are novel to China. They've never agreed to this in the past. Labor, CSR, corporate social responsibility, environment, climate change, and even forced labor provisions, ILO. Now, a lot of these, though, really, again, effectively repeat what China has already agreed to elsewhere. In particular, the ILO provisions and the climate change with the Paris Agreement. Essentially, China's agreed to effectively implement its Paris Agreement obligations on climate change. With the ILO, it is agreed to ratify, to implement provisions of the ILO conventions, which it has ratified. So not all of the conventions of the ILO, only which it has ratified. So these are really just restating the obligations anyway. But again, this is a services and investment agreement. We cannot expect it to be a comprehensive labor and environment agreement. Okay, there are other forums, and it shouldn't fall on trade and investment because other forums don't do their job. Okay, we cannot expect this. And for those who essentially say, well, we shouldn't ratify the agreement because these provisions don't go strong enough, I think that's a mistake as well. To be honest, these provisions are not going to encourage or discourage European companies from doing business in China. European companies that are already there are going to stay there. They're not going to leave because they wanted stronger provisions here. Clearly not. But it will be played out in the media, obviously, during the ratification process and in Parliament. I mean, again, the reality is these provisions are better than nothing, and they're better than not having an agreement at all. Okay, the fourth point to make is, I mean, China's benefits from the CUHK is more subtle. European companies may see that improved business climate in China, but Chinese companies are really going to receive very little direct and tangible benefits, right? Europe was already relatively open and transparent place to do business. The EU has also preserved sensitive areas: energy, agriculture, fisheries, audiovisuals, public services, and of course there is the fairly new FDI screening mechanism, which is also untouched. So if we look, what did China gain? The first is, again, strategic. The strategic value of the CUHK, I think, to China was quite strong. It enhanced China's determination to be seen as an active liberalizer, a partner who can make important contributions to liberalization and development. I think this really is almost kind of an anti-US provision here, in the sense that I say, I mean, the US had viewed really China as not a good faith negotiator who can get a deal done. I think China reaching the agreement with the European Union really wanted this to be a public relations win, to say, yes, we want to push the agenda forward. We are not the roadblock. Someone else is. It wants to be seen as a leader, really, in global governance. And again, there's value in reaching a deal with the EU amidst this increasingly hostile trade environment. Likewise, China benefits by getting locked in gains for the same reason that Europe did. But if we look, really, protectionism's on the rise, and the market access and non-discrimination which China benefits from in Europe, I mean, there's no guarantee without an agreement that those would continue. We're in an age of nationalism, protectionism, and country X first. So China gets an obligation that Europe's not going to roll back those provisions. The last point and the most interesting point is really I say foreign policy or foreign policy games. And this is, looking at this agreement from a really broader perspective. The EU essentially reached this agreement with China, quote, despite US concerns, was a US quote. And the US felt that this took away leverage in dealing with China in a united front. I do question whether why would the US expect Europe to simply fall in line and deal in its dealings with China when in fact the Biden administration, when in fact the US administration had, of course, not only launched a trade war against China, but also reached an agreement, the phase 1 trade deal, which of course Biden has not repudiated or gotten rid of. So while this was an opportunity for the EU to display its strategic autonomy, maybe it's also an opportunity for China to try to drive a wedge between the EU and the US. I think that need not be the case. And given events that have taken place subsequently, I think that's not going to be the case. Instead, the EU and US are really finding common ground in objecting to China's state-led development model and its unequal treatment for foreign enterprises, etc. Now, of course, since the agreement, I'll really conclude here, we have a really changing investment climate. Of course, we know that relations have taken a turn for the worst. The CUHK is frozen. Initially, I expected this ratification to go really the way that China-US relations go. Tit for tat sanctions, and then move on and get a deal done. Instead, that's not what happened. I think the depth and scope of China's retaliatory sanctions was unique against Europe and led to really quite justifiable outrage in Europe. So overall, relations are quite poor. I really believe that China expected and accepted this result. China hit the EU hard with sanctions, and I think the sanctions of the members of European Parliament in particular obviously ruffled quite a lot of feathers in Europe. The insinuation, though, that there was genocide in Xinjiang was, I think, the trigger, was perhaps the red line in China, and China wanted to send a very strong message that those accusations will not be tolerated. So as I said, I think China expected the EU to freeze ratification and accepted that as a result because it was a clear red line. We have even further EU legislative proposals on the border adjustment mechanism, on subsidies, on anti-coercion instrument to deter and counteract coercive practices and due diligence rules that oblige companies to identify, address, and remedy aspects of supply chain, so forced labor provisions. These are all going to exacerbate those tensions. And if I'm making a prediction, if the relations keep going how they are, what we may see is some of the same tactics that China has used in the past against Canada, Norway, Japan, Korea, and is currently using against Australia in terms of mixing trade, retaliation with these broader diplomatic relations. So perhaps European goods might face lengthy delays at customs. There might be distribution issues, maybe reduced market access or consumer bans, etc. If that happens, I think we're going to have a very difficult road to climb down from, to climb down from those actions. So just in conclusion, if we leave that point, I think the CUHK won't structurally change China. State capitalism, its environment, labor provisions are going to really stay as are, but really what can a trade and investment agreement do? At best, what we can hope to is this will lead to other countries essentially negotiating as a bloc, and so we can move relations forward with China as a partner. I caution against over promotion of this agreement because, as happened in January after the agreement was reached, it naturally caused a bit of a backlash, and the Commission kind of had to change its tune. So I will stop there. Thank you very much for listening.
Okay, thank you very much, Professor Mercurio. We now move on to our third speaker, Dr. Christoph Mager, partner and head of the Austrian Corporate and M&A Department at DLA Piper, will give us a presentation on the EU's new FDI screening regulation and its impact on M&A transactions, a practical perspective from Europe and Asia. Dr. Mager, please.
Thanks a lot, and thank you also for the kind introduction, and also for the invitation. I will just try to share my screen so you can see my presentation. Just a second, please. So I hope you can see it. I would like to hear that I'm a partner in the global law firm DLA Piper, and I'm heading the Austrian Corporate and M&A Group. And we saw here that the implementation of the European Union foreign direct investment regime a few months ago, and we realized that it had a significant impact on the mergers and acquisition market in the European Union. And I would like to give you a brief overview about the FDI rules, but I realized that you have here heard some introduction on this the regime before, so I will keep that brief. But then we'll go into the details on the practical the experiences of the past months, so that you have a little bit of a feeling how this changed the acquisition market and the acquisition structuring in our daily lives and the investments from outside of the European Union. We always had a very strong focus as a firm to work for clients investing in the European Union. That's outside from the European Union, as being acted globally and are acting globally, and have therefore a quite good comparison about pre-FDI regime and now living with the FDI regime. As you are aware, so I'll just try to give you some background. That the European Union was always here previously quite open to foreign investments. When I say foreign investments, I mean outside investors outside that are located outside of the European Union. But then realized that they would like to have more control on investments in high-tech sectors such as aircraft manufacturing, machinery, and pharmaceuticals, but also in the IT and the sectors where know-how is the key the development. So they installed a regime compared to other countries and called it foreign direct investment regime. It is a regulation, meaning that it is directly applicable in EU member states, but it then gives also the member state countries the chance here to transform them into a local law, which all of them did. And there was the obligation to have everything effective by October 2020, which all member states kept the deadline and introduced their local rules. What does it mean? Just a very a brief overview from an M&A perspective. It means that if an investor outside of the European Union that intends to acquire the entities that are located in a member state, one or more member states, then he has to watch the new FDI rules. And to mention it right at the beginning, it doesn't really is very investor friendly because all the FDI local regimes are a little bit different. So if you here are look from an investment perspective, you have to watch in each and every member state rules where the target is operating in. And to get a view if you have to apply for FDI confirmation or not. The foreign investor, there were local rules in the past, but they were not in all membership countries, and they were not really that strict because mostly only direct acquisitions were considered. Now we have a very broad definition of what is an investor and what is in a foreign investment. Basically, it means any direct or indirect acquisition, or if you into a European Union located company falls under the FDI the regulation regime. provided that it acts in certain sectors that I briefly mentioned before. The consequences of not applying are quite strong, because basically it means that the acquisition that itself is not, from a civil law perspective, effective, but rather void. So the consequences are quite strict. Besides, there are some administrative and criminal fines if here the purchaser does not apply for the FDI approval. It is, as mentioned, the purchaser obligation to do it, but also not the seller. The seller is totally out and does not have any such obligation. But as a follow-up, if the purchaser misses and doesn't do it, and the local the management that realizes that the investment is done outside the European Union, they also have the obligation to inform local authorities. What does it mean for the timing? It does not have only the consequences. The deals are carefully reviewed and need to be carefully reviewed if you require FDI approval, because if you come to the conclusion FDI approval is required, which basically is quite easily the case if you look at the broad sectors that I mentioned before, you have to consider that the FDI approval that requires a certain amount of time. It is not here that there are certain different layers. There is a kind of EU consultation mechanism where the European Commission will be confirmed. Basically, you always file at the local authority in which the target is acting in, but then also the EU Commission gets informed, and also other member states can here give their opinion, thoughts, statements within such a EU consultation mechanism. Based on the outcome of such an EU consultation mechanism, local authorities have to decide if they either approve or forbid the transaction, or if they say we need a kind of second stage review, which gives them another 2 months, asking details about the transaction itself and get a better overview, which markets are concerned, what customers would be influenced, how the competition relationship within the EU would be influenced, and to get a full picture on the transaction, on the planned transaction. All in all, you could see that this may delay the acquisition processes for up to 4 months maximum, which is quite a lot in an M&A deal when you see that transactions are were done much faster in the past, but really need to be planned around those FDI rules now after having implemented this FDI regime. What we see from a practical perspective, that investors get quite easily made themselves familiar that Europe has introduced an FDI regime, and are carefully here asking for advice to help them, support them, to guide them with the local authorities. What we also saw is that local authorities get used to it, also got used to it quite quickly. There was a lot of here awareness that made also on a government level to have here the rules implemented. But nevertheless, not only from the timing perspective, and not also from the consequences that there may be certain sectors where it gets difficult to make acquisitions for non-EU investors. Certain areas are still totally handled differently within EU member states, and particularly where they are not really seen as here as one approach from an EU perspective. We try to identify them with our past experience and past transactions that we have made over the last 15 to 18 months, and could them identify them basically on those 4 areas. We are in a regular touch with local government and authorities around those 4 questions here to try to find a kind of common rule and common sense. This will establish, I'm quite optimistic on that, but until this happens, there is still quite some uncertainty for investors. Basically, first question is, if an EU entity is already ultimately owned by a non-EU the investor, and a new non-EU investor wants to step in, do we here need FDI rules to apply and act in compliance with? The answer is yes. Although this is not really directly, that it cannot be directly seen from the text in the legal acts, but it's clear from the government's perspective, even if the current ultimate owner is already outside the EU and non-EU investor, even and sells it to a new and a non-EU potential investor, this requires FDI approval under your European regime. Second, are internal reorganizations covered as well? There I would see the most uncertainties around, because big global organizations are reorganizing themselves all the time. And the answer that most people thought at the beginning, when they had also most of the lawyers thought at the beginning, that there's a clear no. That what we know from the authorities and what we learned from the here experiences in the past month, that the clear no is not a clear no, but a kind of yes or no, or yes and no. The answer, it depends. What we saw is that the government or the authorities make a kind of difference if the controlling entity, and by controlling entity I mean the entity controlling the reorganization plan by EU entities, is located in the EU or outside the EU. So they make quite a distinction on that. If it's inside the EU, even if the ultimate controlling the entities outside the EU, they say there is no FDI regime applicable. But if by the reorganization, the control over that European part of a global entity leaves the EU, then the local governments, not all of them, but many of them, as we realized, tend to say, yes, this FDI is applicable. Unfortunately, this is not seen the same way in every member state in the European Union, which gives a lot of practical burdens to global players. Third topic is, what if the local management has no information on the acquisition, as mentioned at the beginning, that if the local management fails to apply and fails to inform the local authorities as the purchaser, who is non-EU, and the investor didn't do so, administrative and under certain circumstances, also criminal, penalties may apply. Is also an issue that at those global deals, local management does not have in practice the information. They don't have the information about who they're non-invest in, how the deal is structured, who the non-EU investor really is, and in where he is located, and also know that it's about his market share, the purchase price of the group, etc. So this is a real difficult topic, putting local management in potential liability towards local authority, as they are not here able to answer those questions. The government is aware about that. The authorities, we discussed it with them in many different member states already.
Dr. Mager, I'm sorry, we're running a little short on time. Would you be able to wrap up in the next 5 minutes or so?
That's perfectly fine.
Thank you.
That's perfect.
Appreciate that.
Here we are in touch with local governments, and the view is, the more you can document that the local management does only have certain information, the better it is. And up to now, it was always possible here to keep them safe. And the last topic, are the local FDI rules similar in other EU member states? Unfortunately not. So if you do a transaction from the structuring point of view, you have to review each local FDI rules, as there are not, most of them is the same, but there are also national differentiations which can here make differences if you apply for FDI regime or not. So this was a very brief overview. I'm aware about that, and some here practical key topics. Thanks a lot for listening to me.
Very much for that. We now move on to our last speaker, or our last panelist. We then have a discussant after that. And that's Mr. Nathan Bush, partner and head of antitrust and competition in Asia at DLA Piper, who will be speaking on the interplay of competition law and trade policy in contemporary China. So Mr. Bush, over to you. All right.
Well, thank you, everyone. I'd like to begin by thanking the organizers, including my colleagues at DLA and the university as well, for inviting me to join the panel. As was mentioned earlier, I'm essentially a forward deployed Washington, D.C. regulatory lawyer. After starting practice in D.C., I lived in Beijing full-time for 8 years, from 2004 through 2012. I was in Singapore, based in Singapore, usually on an airplane around the region up until COVID. I spent the last 2 years in my guest room in Singapore. And as of 48 hours ago, I'm in my boyhood home in North Carolina. So I'm calling you this morning from about 5:30 in the morning on the East Coast of the US. And I appreciate really the chance though to join in the discussion. I've got about 10 or 15 minutes, and I'm going to be delving into two regulatory fields that have an intersection which can constrain the way in which market actors, I'm talking about firms, I'm talking about Chinese firms, American firms, European firms, firms from other parts of the world, have to navigate when developing and executing their commercial strategy in trade and investment into China, into the EU, and into other jurisdictions. And that'll be the trade and competition fields. So I'm going to share my screen, and we will go from there. Just give me one moment to get it open. And it's not showing up yet. One moment. Ah, there we go. All right. So just to open up, I'm beginning with a graphic metaphor that I've often used to remind people to keep 2 or 3 concepts separate when they're talking about barriers to trade in goods, trade in services, and investment market access when comparing jurisdictions. That sometimes there are differences in the relative absolute level of commitments for market access given to partners. Sometimes there are differences in the level of what was bargained for. And so sometimes those differences arise from differences in commitments that were made in the first instance. And sometimes those differences because of can be more conspicuous given the type of regime in which they're operating. It's kind of abstract, but looking back when I first moved to China, right after the WTO phase-in period, the WTO plus commitments milestones had just ended. It was the Hu Jintao period. It was a time of looking and pushing for further liberalization and further market access across the board. It's a time when the anti-monopoly law was under drafting. And the earlier mentioned incident of the UNICAL prohibition by CFIUS in the United States, the Committee on Foreign Investment in the United States, blocking a Chinese state-owned energy company from acquiring a US-controlled company, made waves. It was very conspicuous at that time. And I recall being in an AmCham legal committee discussion, and we were talking about comments going in on new laws. And the point was made that in an ideal sense, if you're looking to facilitate liberalization, you could easily have an extraterritorial competition regime to manage anti-competitive agreements, abuse of market power, concentrations on a cross-border basis. You could have a disciplined sentry at the gate, national security foreign investment screening system. And with those in place, you would then have a basis for a much more liberal, much more open FDI regime. And in many ways, the new Chinese FDI law has moved in that direction. But it's moved in that direction at a time when many of the other regulatory instruments have unfortunately gone in quite the opposite direction, one towards more uncertainty, more restrictions on effective or threatened market access. And that's the context we'll be talking about trade actions and antitrust. Again, this yet another metaphor. I find that both Chinese firms, American firms, European firms, trying to navigate the trade compliance risks they face involves a difficult task of steering between expectations set often in Washington, D.C. under US trade and export controls, and those increasingly being articulated in Beijing under the counterpart measures being adopted by the Chinese government. Briefly, from a US perspective, where our nomenclature separates export controls and sanctions. These risks have been in place for a long time, but it became much more acute under the Trump administration, at least as they impact U.S. and Chinese relations. On the economic sanctions side, there are the risks that entities will be designated specifically as specially designated nationals subject to export control, subject to sanctions. There are also broader prohibitions on U.S. persons being involved in dealings with countries and regions subject to comprehensive sanctions, and targeted sectors within Russia in particular. Now, most of those rules are primarily addressed to not the targets of sanctions, but to U.S. persons and entities. It's a restriction on U.S. parties dealing with them, with sanction targets. Nevertheless, there are a number of very sweeping aspects of U.S. sanctions law that can reach third country actors. Hidden involvement of U.S. persons in their activities that create jurisdiction. There is a rather broad statutory construction where the relevant U.S. laws prohibit not only direct sanction violations, but causing violations. So taking steps to deceive or induce a U.S. person to breach sanctions can expose a non-U.S. person to liability. Use of U.S. dollars is actually one of the greater pitfalls here, because use of U.S. dollars in international transactions entails actions in the United States and gives rise to jurisdiction. And then broadly, the use by the U.S. government of secondary sanctions, targeting third country companies, third country actors, not for what they've done, but for continuing to do business and having interactions with primary sanctions targets. It's effectively punishing a target's continued friends. Those have created a substantial and growing area of regulatory uncertainty for companies dealing in jurisdictions where there are a lot of SDNs, and that increasingly includes China. At the same time, the US government, it's in some ways predating the Trump administration, has moved to a more aggressive and in some ways more expansive view of national security, somewhat ironically like a Chinese view, to bring in a broader view of products, technology, software under US export control restrictions. At the same time, during the Trump administration, an element of US export controls became effectively a diet version of sanctions, and that's the entity list designation. Rather than designating a Chinese company for sanctions, which has extraordinary effects for cutting them off from dealings with US companies, export controls and entity list designations are much more limited on severing product sales. So it became an intermediate measure under the Trump administration trade policy. Nevertheless, that's still in place and continuing. So the bottom line here is European companies dealing with Chinese counterparties, as well as Chinese companies themselves, were increasingly concerned with the ripple effects of US export controls and sanctions. Well, there's a saying of sauce for the goose is sauce for the gander, or perhaps sauce for the dragon is sauce for the eagle in this context, because what we've seen in the last 2 years has been a very methodical expansion of the Chinese government's economic policy defense toolbox. And this started with the Ministry of Foreign Affairs, increasingly imposing sanctions on particular foreign individuals and some entities as well. Then in September of 2020, the Ministry of Commerce issued the unreliable entity list provisions. This was effectively a regulatory framework for list-based sanctions like the American SDN system under OFAC. Then in October, the NPC adopted on an accelerated basis the export control law, which took what had been a patchwork of discrete export control regimes and stitched them together, integrated them. And in doing so, it also created the legislative foundation for an entity list for restricting export privileges for domestic companies and, more importantly, foreign targets based on conduct adverse to Chinese policy interest. Then in December, the NDRC and the Ministry of Commerce issued the Measures for Security Review of Foreign Investment. This is a little bit different of a bullet point. As I mentioned earlier, the foreign investment law went to great lengths to increase the or reduce the red tape and discretionary steps constraining market access in many sectors. Domestic law moved from the traditional buckets of encouraged, permitted, and restricted sectors to a negative list model. And in doing so, it removed many of the traditional touch points where the Chinese bureaucracy would have an opportunity to formally block or informally deter and extinguish problematic investments just coming up through the routine FDI regime. With that gone, there's a need to compensate. And so this is effectively a strengthened Chinese counterpart to the American CFIUS process or the European FDI regimes. And it has been active. It has been reaching out and asking parties to make notifications. And then in January of last year, the Ministry of Commerce released the rules on counteracting unjustified extraterritorial application of foreign legislation and other measures. And that's effectively an analog to the European blocking statutes for blocking compliance with foreign sanctions. And in June of this year, with much foreign coverage, the anti-foreign sanctions law was adopted, and in many ways expanded some of these earlier measures. Now, there's a bit of irony here. You see elements of convergence. Many of the technical aspects of these rules are clearly adapted from foreign models, but this has now created a situation where the same formal mechanisms for deterring commercial actors from engaging in conduct adverse to Chinese interests or punishing or retaliating against such conduct are now much more clear. So this raises a question: if this formal structure is now more robust, what does that do to areas where there in the past have been concerns about implicit or tacit collateral retaliation just through the domestic enforcement of Chinese laws? And one of those areas would be the anti-monopoly law. And asking the question of the extent to which the anti-monopoly law may be used collaterally for trade policy or industrial policy reasons is a vexing question. Clearly on its face, the text of the anti-monopoly law it's written in a way that allows other policy interests to influence enforcement decisions. More importantly, a number of scholars who've applied political economy models to looking at decision-making within the Chinese competition authorities as part of the broader bureaucracy have seen ways in which the policy-making context around that text makes that possible. But actually quantifying and gauging the impact of these other issues on a law that otherwise would appear to be focusing on consumer welfare and economic efficiency, that's challenging. The record is sparse, and the translucence, the relative opacity of Chinese regulatory procedures compounds that challenge. At a high level, though, you can easily look at the record of the first 12 or so years of AML enforcement, and you kind of see two narratives. One narrative is an evolution of default competition rules that apply to almost all actors in almost all sectors, almost all situations. And those default competition rules, in terms of the messages being telegraphed to an individual, a firm, are very similar to the formal competition regimes of the EU. The vast majority of domestic conduct rule enforcement cases have targeted domestic players in local markets.
Mr. Bush, I'm sorry. Would you again be able to wrap up in the next few minutes? Thank you very much.
Of course. Yeah. So on one hand, the actual enforcement record has been one of these default rules being very consonant with international practice. And without going too far into the last 2 years of the techlash, the surge in enforcement targeting China's domestic e-commerce sector. Without going into the merits of their specific theories of harm, what is remarkable is that's a sector where foreign investors have been historically largely fenced off for a variety of legal, regulatory, and architectural reasons. And in that space, you've seen very robust enforcement that, on one hand, is aligning with what appears to be a broader policy agenda from the senior leadership, but also is not necessarily out of step with the greater upheaval in global competition policymakers about how we should be applying competition rules in the online sectors. So that's one narrative, and that narrative is that most of the antitrust rules applied to domestic parties in China seem to be default conventional antitrust rules. But at the same time, there is this concern that if it were to be wielded as a trade instrument, the AML is potentially a very, very potent one. Both under the Trump administration and the Biden administration, the USTR has made findings echoing Foreign Trade Association concerns to that effect. When SAMR actually released new implementing measures on merger control, it included an explicit provision disavowing discriminatory enforcement with a long accompanying public statement, effectively acknowledging the criticism. But when you look through the record, there are clearly a number of areas where the risks are greatest. In the conduct rules, there really hasn't been evidence of a surge in discriminatory enforcement that is very clear. Concerns right now tend to be greater in the merger control area, where there are administrative options to slow down or impede deals that may be deemed hostile to industrial policy goals. There are also some elements of the remedy practice that have raised questions. In one published case, there were remedies that were not public, and there were concerns that they had to do with national security or industrial policy related aspects of the merging parties' operations. In another, there was a remedy that very much seemed to lock in a commitment by the foreign parties to continue supplying Chinese companies in an industry that was increasingly under threat of American sanctions, perhaps neutralizing those sanctions. And then we also have concerns that can be raised if you look at some of the trends involving standard essential patents or the notion of commercially essential patents. The Hitachi Metals case earlier this year raised the possibility of declaring commercially essential patents essential facilities and imposing on dominant firms that are dominant in their own IP an obligation to license, even though they hadn't made any FRAND commitments through a standard setting process. So this is an area to watch. I would just close by saying that there is reason to think that these areas are linked in the higher framework of policymaking. If you look in the 5-year plan that was released earlier this year, there is a passage which talks about the national security review systems, the export controls, the unreliable entity lists, and the anti-monopoly law, all as being part and parcel of the measures needed to balance the progressive opening under the foreign investment law. So just to close off, this is going to be an area to continue to watch because the possible interplay of how trade and industrial policy will influence competition policy is one that I think the questions are, well, the book is still open on. So I'll just pause there. Thank you all.
Okay, thank you very much, Mr. Bush, for that presentation. Let me now turn over to Joel Slavatsky at the Harry Radzner Law School, Reichman University, Israel, to give his remarks. We will go a little bit over 7 o'clock, so I apologize to everyone that we've run a little late, but I hope that you can stay with us. So Professor Slavatsky, please. You will need to unmute yourself.
Am I unmuted now?
Yes. Perfect.
Okay, great. Okay, I know we're under limited time, so I'm going to speak as expeditiously as possible. First of all, I can't thank everybody because it would take up too much time, but I just want to specifically thank Dean Wolf. Under Dean Wolf's visionary leadership, the CUHK goes from strength to strength. It is really, really impressive. I've participated in some of these conferences and seminars. Actually, I was in the exact room that you're in back in November of 2016. But over the last year or two, I participated in many of these, and I really want to say that the dean's leadership is just really, really fantastic, and continue on. Let me just give a few remarks. Actually, let me say something about the ambassador's remarks. And I know that he's not a presenter, but his remarks were fascinating and actually spoke to me because I'm writing a chapter on the new dimension in the U.S.-China trade war, specifically focused on human rights, which will be out sometime next year. And his remarks were really, really good. Let me speak a little bit in general about the topic of today, and then I will intersperse those remarks with some questions to the specific questions to the specific presenters, and then I will stop, and then I will let you, as Master of Ceremonies, Rihan, you guide how much time they each have to answer the questions. Gone are the Halicon days, from the U.S. perspective, that engagement with China, economic engagement, would lead to a liberalization in terms of granting rights and freedoms and falling within the rubric of the US-led order. I'm not saying that China was right not to do it or right to do it. I'm just stating from my perspective what the facts are. And they didn't. And I think it's a mistake to focus in on the Trumpian the initiation of the trade war from Trump as the beginning of the deterioration, because the deterioration actually began under Obama. If you all recall, Obama pushed for the TPP, and he specifically stated that the reason the TPP is very important is that the United States should continue to make the rules, that Washington should make the trade rules and not Beijing. He specifically stated that. And the reason is very simple, because you all know what the golden rule is. He who makes the rules owns the gold. I actually coined that at a previous CUHK conference when I was in November of 2016. I think it makes a lot of sense. And you recall that when Obama visited at the end of his term, I believe it was 2016, he did not receive the red carpet that Angela Merkel received, the red carpet that Prime Minister May received, all the other European leaders. And he actually stated in an interview that the seams are showing. So it's not so much that Trump started the deterioration. I think he basically put it out in the open. I think the deterioration was already starting under Obama. And I think that this new paradigm of human rights is really, really fascinating, because it is something which kind of galvanates and resonates with the public. I think all of you know that the EU, as well as in the United States, there was a very, very big move for corporate responsibility, corporate social responsibility. In fact, even in the United States, former Chief Justice Leo Strine, he authored the Marchand ruling a couple of years ago. And the Marchand ruling basically said that directors of publicly traded companies have an enhanced duty to monitor, basically stating, and there's been a few decisions after that as well, stating that Delaware directors really need to make sure that the companies don't do something improper. They have a duty to the public itself, to society in general. Again, I'm not commenting whether this is right or wrong, but this is astonishing, and take into account also the Business Roundtable in the United States, where you have CEOs basically saying you don't really need to only focus on shareholder value. So you've got this pressure, and this is where it connects to human rights. You've got pressure on businesses from the public in Western countries. You've got regulatory pressure. You have potential lawsuits, enforcement proceedings. And how does a corporation balance that out? An EU company that wants to do business, how do you balance out? As Dean Wolf said, China is a mega opportunity. It is a mega power. And how do you balance that out? I don't know how you do it. And you also have, as was referenced just from Nathan, he mentioned the blocking statute, anti-sanctions laws. There's also negative repercussions. So even if a company adheres to Western regulators or concerns from the Western public, then they risk backlash from Chinese consumers. So it's really not very, very simple. And now I'm going to get to the actual comments, the presentations, and I will ask one question for each. First of all, Dini, that was a fantastic presentation, great insights. I particularly was enamored that you stated that there is a dichotomy between development in the eastern region, the coast of China, which has been booming, notwithstanding Evergrande, and the western region. And I'll answer this myself because I think it's somewhat sensitive, and I'm not going to ask anybody to answer it. But the push to boycott, as the ambassador mentioned, products from Xinjiang because of forced labor, on one hand, that sounds very noble, and that is a ramification of Western ideals. However, isn't at the same token you are keeping back development in Xinjiang, in the western region of China? Again, I'm not commenting whether it's right or wrong. I'm just raising it up. As a particular question for Dini, the conceptualization of national security has been expanding very rapidly. It used to be physical attacks to a territory. It is now encompassed economic security. Data security is very important. Obviously, some of this is dual usage, hypersonic missiles, space warfare, so on and so forth. Isn't there a danger, or is there a danger of this being a slippery slope? Where do you draw the line? I mean, every device that's connected to the internet is a potential data point. So again, I'm not saying it's right, I'm not saying it's wrong, but where do countries, the United States, the EU states, China, where do you draw the line? I want to note that China is also very expansively expanding its notions of national security. It's considered national interests, social stability, economic stability. So it is not only the Western countries. And my question to Dini is, do you see that continuing? Maybe it's going to continue, maybe it's not, but I'd love to hear your insights. Brian, obviously fantastic. I really enjoyed your presentation. And just to save time, let me get right to the question. How do you think EU businesses will balance out the pressure from, I would call it the three levels, the United States, the Biden administration and their new emphasis on human rights, EU states themselves, and the risks of backlash from Chinese consumers? Christoph, wonderful presentation on FDI and various the regulatory regimes. My question to you is, since you're in private practice, and I used to be in Denton, so I think, I understand that you might have limitations in answering this, but your clients are publicly traded corporations. I presume a lot of them are, or all of them are, as I had Fortune 500 companies. The directors of your companies, how do they feel about this movement of human rights? And I understand, I'm talking about the gray zone. I understand that they have to be cognizant of government regulation. I understand that they have to be cognizant of potential government enforcement proceedings, but there's always gray zones. It's not always black and white. There's an area in which you can operate legally. There might be ethical questions for some people, but how do the directors, what kind of feedback are they receiving from shareholders, both public and institutional? How are they going to, in your opinion, balance this out? What do they think is the bottom line for their companies and human rights? And lastly, but certainly not least, really fantastic presentation from Nathan. You mentioned how U.S. banks and using U.S. dollars can confer jurisdiction. And, it's interesting because it's going to become more challenging because of the rise of virtual currencies such as Bitcoin. You don't have to use a SWIFT bank. You can just, I can just send, not that I would, and I'm not advising anybody to, but if you want to violate the Foreign Corrupt Practices Act, as long as you avoid a U.S. bank or a correspondent bank, I could just send it I could send my Bitcoin from a European exchange to anywhere in the world. And if it's not connected to the United States and I'm not a U.S. citizen and I don't have a green card and I'm not a U.S. business, there is no jurisdiction from the DOJ or let alone the SEC. So my question to you is, in terms of extraterritoriality. And I wrote an article in the Georgetown Journal of International Law. So Nathan, your topic is really, I loved it, on extraterritoriality. As you know, and you obviously you worked in Washington as well, maybe at the DOJ, Justice, or Treasury, I don't know where, but one of the let me back up for those of you who don't know, because I'm speaking now, I'm getting too into the lingo. There's a presumption against extraterritoriality in US federal courts. And once you overcome that presumption, the federal courts may have jurisdiction if, there's a couple of ways, but one of them, the principal one, is if there are effects, domestic effects within the United States. My question to you, Nathan, is as follows. Do you think that the hegemonic rivalry between the United States and China kind of changes the equation? Let me explain what I mean. You could have a state-linked Chinese entity that conducts business around the world. Ordinarily, it's a purely private act, but if it is a state-linked company, does that change the ordinary act of doing business or conducting business into something more, I don't want to say a Trojan horse, but something more that can kind of give rise to domestic effects that the regulatory authorities in the United States could go to a court, a federal court in the United States, and say, listen, this conduct that they're doing, you know what? It sounds purely private, but it actually has national security ramifications on the United States. It may not be immediate, but it's somewhere down the road. That's it. I'm going to leave it now for our glorious master of ceremonies, because I know it's already a few minutes after, and please divide it up as you see fit. Thank you very much. It was wonderful being here.
Oh, thank you so much. And thank you for posing a question to everybody. That was terrific. I'll just say quickly that Professor Brian Mercurio had to go. He had another presentation to make, I think at 6:45, and he sends his apologies. So we won't get to hear from Brian, but maybe I can ask each of the other panelists to give a brief, and I do mean brief, response to these terrific questions. And let's just go in order of the program. So can I ask Dini first?
Thank you, Professor Zlavotsky, for your question and also for being a discussant. So yes, your question actually is very interesting. And what you are asking is more evident in the case of the US legislation, such as the CFUs, because it is more like an older legislation, which was drafted initially in the 70s. And in those years, the connection was more evident with the physical protection and the physical security of the infrastructure, so limited to very specific areas. And now the meaning has changed. However, this is a less evident phenomenon in US or and in EU member states legislation, because these legislation are fairly more recent. For example, the Italian legislation on the screening mechanism was just drafting in 2012. So they already cover more modern aspects. And as for the expanding meaning of national security, we can see it is quite evident. For example, as you mentioned, the national interest is the case of Canada. And in that case, and also when the meaning is quite broad, it gives the executive a great amount of flexibility to make their own choices. So this is also very interesting phenomenon, because we are dealing here with fear. So we don't really know if the foreign investments held by state-owned entities or private entities that are under the influence of a foreign government will necessarily commit nefarious act in the host country. So we can have a government in a European state who is more favorable towards Chinese investments or another country investments, and will not perceive those as a threat. And then we will have maybe another government who will perceive Chinese entities as a threat. So this is it is a very political question. But what is also a very positive development is that a recent legislative changes, especially the EU regulation on the screening of foreign investment. It provides some objective criteria. Of course, also within the list of objective criteria, there are some that can be interpreted very broadly. So it is, as you said, slippery slope. Thank you.
Thanks very much, Dini. Can I ask Dr. Christoph Mager for his response, please?
Yes, many thanks for the question. I think it's a very relevant one in daily practice. And honestly, the directors and leaders of non-EU investors basically were expecting that the FDI regime will also be introduced in the European Union. So they are not surprised that Europe went that way and introduced the regime. But there are two things that keeps them worrying. One thing is the time frame, and this was also quite surprised when the FDI regime was introduced, that it gives significant and here time to authorities, local authorities and EU authorities to review the transaction and to analyze it and to give comments, to ask questions. So this is really quite a long proceeding where here we, from a practical the view, would have expected to be around half of the time that actually the authorities that here now have. As we see from daily experience, authorities also use the time. So there is hardly any example where you got faster results. The second thing is that basically there was the expectation that before FDI regime was introduced, that it will be similar in all EU member states. And now you have basically quite similar rules in 27 countries, but not totally similar rules. This really creates burden also in daily life when you then have to dig into the different mechanisms of each member state. So there was not really, this was not expected, and there was really the strong the expectation that the EU would introduce one regime for all member states. Thank you.
Thank you very much. And then finally, Mr. Nathan Bush, please.
Okay, it is a peril to raise the notion of extraterritoriality as an overtime question when tackling multiple statutory regimes and bringing in the FCPA as well. I'm going to pick and choose and answer your question with another question rhetorically, which is particularly in the area of sanctions. And I'm going to set aside FCPA type enforcement where there's some very aggressive theories of assertion over foreign personnel acting for US companies as a matter of anti-bribery and broader securities rules under the FCPA. And then in the other direction, affects jurisdiction in the antitrust regimes, which are, for better or worse, fairly universally accepted as kind of the bed we've all made to lay in. In the area of sanctions, there is this ongoing public policy debate on the circumstances in which tagging entities as SDNs, putting them on the entity list as a specific measure to change commercial actors, state-owned or not, their willingness to go along with their own home government's policy. That's a very controversial measure that we've seen escalating in the recent years. And in some ways, it was a logical transition of, post 9/11, early thousands, post-Soviet Union sanctions policy when they were more worried about non-state actors. And the idea was you could designate a non-state actor and change its conduct. Now that we're going after constituents of state actors, and that's what the US has been doing, that's what the Ministry of Foreign Affairs sanctions have thus far been doing to civil, elected leaders and public policy advocates in other countries. It is starting to ask the question of where the pushback's going to get to be too much. And that is an area where I don't think we're looking at much as a legal resolution systemically, You'll find legal resolutions within each discrete regime, but I fear that and this is just a personal opinion, I fear that you need to be looking at power dynamics more. That's more of a political question than a legal one in the end. So I've dodged your question. I hope I get to do that at 7 in the morning, but well, 6 in the morning.
Terrific. Thank you all again very much. Let me also thank the organizers again. So Dini, folks at UCL, folks at DLA Piper, very grateful to you for putting together this seminar and this series. Let me apologize to the folks who sent me questions via chat. We're now way over time, and unfortunately, I can't take those.